Today we'll discuss another important concept under Islamic law, and that is Shuffa or pre-emption. And that Shuffa or pre-emption was started in India with the establishment of Mughal rule. So it was applicable to all people, including the Hindus, and the very idea of Sufa and its very definition we found in the Hidayah in volume 2, where it was said that a Muslim and non-Muslim being equally affected by principles on which Sufa or preemption is established and equally concerned in its operation are therefore on an equal footing in all cases regarding the principles of Sufa. When the Britishers' rule was established in India, the preemption existed in some part of the country either as a part of Muslim law and in some parts by virtue of custom. In some cases, it had also come into existence by contract, and as it was expressed in the leading case Awadh Bihari versus Gajadhar in 1954 by the Supreme Court, and the British India courts were not required to enforce the preemption as part of Muslim personal law, but as a matter of justice, equity, and good conscience. The Madras High Court refused to enforce the law preemption since it felt that it was against justice, equity, and good conscience to give it effect, as it placed restrictions upon the liberty of alienation of property, as it was upheld by the Madras High Court in 1870 in the leading case Ibrahim versus Munimir on the basis of justice, equity, and good conscience. So now we'll go to the various sources of Sufa or preemption. So the law of preemption has the following four sources. One is Muslim personal law, and the second one under the statutes, and the third one by custom, and the fourth one by contract. So regarding Muslim personal law, in the greater part of the country it existed among the Muslim as part of their personal law, as per example, where the law of preemption is neither territorial nor customary. It is applicable as between Muslims as part of their personal law. And regarding the second one, under the statutes, it existed in certain parts of the country under statutes. Thus, in Punjab, it existed under the Punjab Pre-emption Act 1915, in Agra under the Agra Pre-emption Act 1922, and in Awadh near under the Awadh Laws Act 1876. In these areas, the statutory law of preemption applies to both Muslims and non-Muslims, and the Muslim law of preemption does not. apply even to Muslims. This should be read subject to the giving saving contained in the Agra Pre-emption Act, and the third one, that is in Bihar and Sylhet in Assam and certain parts of Gujarat such as Surat. The right of preemption is recognized by custom among the Hindus who were either domiciled there or were natives of these parts. In these areas, it was the Muslim law of preemption which applied to Hindus except in so far as it was modified by custom. And the fourth source, that is by contract, among some people it came into existence by contract. The right of preemption was created by contract among the sharers in a village. For instance, a Hindu bhandi and a Muslim vendor may agree that the Muslim law of preemption, which applied to the vendor and his sharers, would also apply to the bhandi. And now we'll go to the very definition and meaning of Shuffa or pre-emption as given by Amir Ali, Mullah, and the very meaning of exactly what it means as Shuffa or pre-emption. So, according to Amir Ali, the foundation of the right of pre-emption is the human desire to avoid the inconvenience and disturbances which is likely to be caused by the introduction of a stranger into the land. And according to Mullah, the right of Shuffa or preemption is a right which the owner of an immovable property possesses to acquire by purchase another immovable property which has been sold to another persons. And regarding the very meaning, under Muslim law, death of a person results in the division of his property into fractions. If an heir is allowed to dispose of his share without offering it to other co-heirs, then it is likely to lead to introduction of strangers into a part of the estate with resultant difficulties and inconveniences. In view of this, the law of preemption imposes a limitation or disability upon the ownership of property and compels him to sell it to his co-heir or neighbor, as the case may be. The person who is a co-sharer in the property or whose property in the vicinity gets an advantage corresponding to the burden with which the owner of the property is saddled, even though it does not amount to an actual interest in the property sold. And now we'll discuss regarding the views of different schools in Islamic law. Among the Sunnis, the Hanafi school holds the right of preemption or Shuffa to the fullest extent and recognize three types of Shuffa. One is Shafi Sharik, the second one Shafi Khalid, and the third one Shafi Jar. And the Shafi's school allows the right of Shuffa only to the co-sharers, and among the Shias, the Fatimid school, Itna Asari school, and the Ismail school, they hold the co-sharer right of Sufa. It does not recognize the right of Sufa to the neighbor or participator as under the Fatimidi school, and the Itna Asari school holds the right of Sufa only when there are two co-sharers. Even it recognizes the right to an woman but does not recognize the right of Sufa to neighbor or participator, while the Ismail school holds the view as laid down by the Fatimidi school. Further, they rejected vicinage as a basis of the right of pre-emption or Shuffa. So, regarding the Hanif school, the right of pre-emption or Shuffa as to the full extent and recognition of the three types of Shuffa like Safi Sharik and Safi Khalid and Safi Jar, we would like to discuss when we will discuss about the very classification of preemptors. So these three different kinds of preemption as recognized by the Hanafi school, which is a major school among the Sunnis, and those are like Safi Sharik, Safi Khalid, and Safi Hijab, we would like to discuss in our upcoming video. So also the very right of preemption as we found under the Sunnis and Shias, and regarding that we would like to discuss one of the very important leading case, that is Pasha Begum versus Said Sabu Hassan of 1956, and the judgment was delivered by the Hyderabad court.